Welcome to Commercial Real Estate Pro Network CREPN Radio. Thanks for joining us. My name is J. Darren Gross. This is a podcast focused on commercial real estate investment and risk management strategies. Weekly, we have conversations with commercial real estate investors and professionals who provide their experience and insight to help you grow your real estate portfolio. Today, my guest is Jeff Love. Jeff is a partner at Gibbs Giden Attorneys at Law, and they focus on real estate transactions, or rather Jeff does focus on real estate transactions. In just a minute, we're going to speak with Jeff about how to negotiate a lease on your terms as a real estate investor without being a jerk. We can also talk to him about what to look for in your purchase agreement in a commercial real estate transaction. And gone but not forgotten, what happens to a partner's share in your business when they leave or die? But first, a quick reminder, if you like our show, CREPN Radio, there are a couple things you can do. You can like, share, and subscribe. And as always, we encourage you to leave a comment. We love to hear from our listeners. Also, if you want to see how handsome our guests are, be sure to check out our YouTube channel. And you can find us on YouTube at Commercial Real Estate Pro Network. And also, if you would, please subscribe. The more subscribers, the more often people see us, and helps the whole algorithm, et cetera, et cetera. With that, I want to welcome my guest, Jeff. Welcome to CREPN Radio.
Thank you for having me.
Well, I'm looking forward to talking with you today. And but before we do, if you could take just a minute and share with the listeners a little bit about your background.
Absolutely. So I'm a real estate guy down to the bone. Always wanted to be in commercial real estate. So I actually went to law school to learn more about the law, but really, what goes into a transaction, what goes into a corporate deal, a real estate deal, with the intention that after law school, I was going to practice, be a lawyer for a couple years, and go off and be a real estate developer. And after law school, I graduated. It was another recession. Ended up going to work for two different companies, a scrap metal recycling company, and then I moved over to the real estate developer, and knew I hit the right spot. I loved what I was doing, but I wanted to work with different types of clients. Big ones, entrepreneurs, startups, established companies, doing leasing and purchase and sales and financing. And so I left my job with the developer, and I came to my current firm, and that's what I do on a daily basis. We have clients that are just starting out in real estate to Fortune 100 companies, and we help them with purchases and sales, doing leasing, financing deals, syndication, corporate structuring. So I really get to deal with all aspects of a real estate deal. And that has been really fun for me, because I get to see all parts of the deal rather than doing one transaction with one client. I get to help many different clients in different parts.
No, that's great. I really appreciate that wide perspective. I think so often, people get going in a particular angle or particular direction or specialize, and they may not come in contact with somebody that has a broader picture because they're trying to get their one thing done, and they may not even think to ask questions that could help them, whether it be right now or in the future, or a lot of times I think people don't understand that the exit plan is critical to getting started. So I'm assuming you have some insight on that.
Absolutely.
So let me ask you, how long have you been practicing law?
I have been practicing, this is about 12 years, solely in real estate and corporate transactions.
All right. So you mentioned the range of clients you deal with. Is there a typical client that you work with?
It really isn't. It's fun, and I think that's part that's fun to me is, I'll give you an example. Is we had a client that acquired a 3-unit triplex, and they tore it down and built townhomes, and that was their first project. Really young guys, graduated from USC's MRed school, and now they're, years later, they're a much bigger client doing, developing 50-unit apartment buildings. So one of the nice things is when we have smaller clients, a lot of times they'll grow into much bigger clients, and we'll get to do different deals with them. So we really do work with a range of clients, and that's one of the things I like about my practice is you get to see issues from small and large, and really pass the lessons on from those that have gone before you and that have experienced onto those new clients starting out, to try to guide them to make sure they're not making the same mistakes.
So let me ask you, I mean, because I love that as well about real estate, is if you have somebody who starts off small, and before you know it, they can grow and have a significant portfolio, and and I think one of the things that I've seen over time, and I'd be curious from your perspective as an attorney, when someone starts out as just kind of a smaller entity, maybe they start off as an LLC, a solo or single member entity, and that, how moving from that operation to a larger operation, is there a lot of strategy that you guys work through in the beginning to try and bob and weave as they grow, so you don't get caught in any of the potential issues? I think it's more what I've seen is if you're a C corp or something like that, where it can be more troublesome. But are there some deep dive strategies that you guys get into for that?
We do, and I think it's a lot of high level planning. When you start your first project, we've had clients that, I hate to say it, but watch HGTV, and I'm going to go and I'm going to flip my first house, and they just jump into it, end up, for the most part, losing money because you haven't really evaluated, underwritten the property, but getting a wild and crazy start like that. And then as you learn from that project, and if you do it right, you're going on to another one, a bigger one, multiple projects. It's really evaluating many things. One is, do I have the right corporate structure, which you alluded to. A C corp often isn't the right structure because it's inflexible with real estate. You're paying a second level of corporate tax. You really want something with paths to taxation that's easy to bring partners in and out. If you have investors, maybe you want a special waterfall with how you're distributing cash flow and profits. So making sure you have that entity in place. And as you grow, really thinking at a high level, where am I going with this company? Do I have a 3-year, 5-year, 10-year plan? Do I have a partner? And if I do have a partner, do they have the same plan? I've had clients in the past where maybe one of the two partners is younger and one is older, and the younger one wants to keep pumping money back into the company and grow it, while the older partner's thinking more about retirement, his exit planning, wanting to get that cash flow and enjoy retirement. So it's making sure that as you grow and as you look at this company from a high level, that everyone's on the same page with a strategic progression throughout the company's life cycle, or the investment property's life cycle.
Yeah, I remember years ago I had a customer, and as an insurance broker, we get introduced to a lot of different topics. Obviously, succession planning and the conversation of life insurance comes up in that. But one of the very few customers I can recall that actually had a plan, in the beginning, and it was kind of the reference point for any time anything came up on it. It was about how do we undo this thing? That was basically the, rule one in his eye was, you start business with a very clear plan of how you're going to get out of business. And it made it very clean when years later, the two partners decided to go their own way. And, because they had instilled the plan, they had revered the plan, they had updated the plan, and it was a kind of a more of a living document, as opposed to something that was nobody could remember where it was or what it said, kind of thing. So that's good.
That happens a lot. I think it's hard to plan out the next 20 years of a real estate investment at the outset, if that's what your goal is, or if it's value add. But it's being able to have that flexibility and being fluid as things change, or maybe one investor or partner wants to leave and you're able to bring in another one. but it's thinking through some of these issues at the outset, so when it does come to fruition, if it does, you know how to handle it.
Right. So on that note of partners, I know one of the topics here I'd written down was the gone but not forgotten. What happens to your partner's share in your business when they leave or die? Can you address that?
Absolutely. It's one of the topics, it's a hard topic to discuss with people, because what it means is, what we've just been talking about. Say we're partners and, one of us is older and, God forbid something happens. One of us passes away, we become disabled, we get divorced. How does that affect our partnership? If we're syndicators or developers and we have a company together, especially if it's just two partners, because you have that 50-50, inherent conflict. How does that get resolved? And a lot of times when we have, new entrepreneurs, new real estate investors, and they want to partner up, it's a conversation to have, is what happens if that partner is gone. So for example, you start a real estate investment company, you buy a 5-unit building with a partner, that partner passes away. Well, does his interest go to his children? Does his interest go to his spouse? If it's an operating company and you're actually doing further projects and you're actually working for the company rather than a passive investment, it becomes a really important question, because that partner's spouse or children, they may not know about the business. They may not bring anything from an operational standpoint, and you may not get along. I mean, you love your partner, but you can't stand his wife or his kid. So what we talk about is called a buy-sell agreement, and it's commonplace with a partnership or an operating agreement. And what it does is it outlines what's going to happen. Call it your business prenup, and it says, if someone dies, does the company have to repurchase my shares? Does it have the option to do it? Can I use life insurance to defray some of that cost? Are the payments paid over time? And it really goes through set triggering events like a death, a divorce, disabled, someone wants to leave the company, and you plan out ahead of time what's going to happen to that equity or those shares in that company, and figure out how are we going to value the company, how are we going to repay that, so there isn't a big dispute in the life of the company, and the fact that the company will continue is insured because we've dealt with these hard issues up front, and there's not a fight when some unfortunate event occurs in the future.
Yeah, I can tell you firsthand. I've seen it up close and personal. Um, I question for you. Would you? Well, I guess I'm trying to think of the way it says. So, two partners. One's a majority shareholder. The other one's the minority shareholder. You've got the majority shareholder is well capitalized. The minority shareholder is not so well capitalized. In my experience, I've seen the majority shareholder not be so concerned about the event, recognizing that if the minority passes away or whatever drops out, a check could be written or something along those lines. But the minority shareholder, I would guess, is kind of more of the vulnerable one in that situation. But I'm kind of curious. Have you had any experience with just that the unequal I guess ownership percentages? Is that anything you run into?
It does. It happens a lot, and not just the unequal ownership, but partners' relative capital positions. We dealt with the similar situation last year, where this one was a 50-50 partnership, but one partner was a billionaire and the other partner was not, by a large margin. So it was much easier for one partner to write the check than the other one. In your example, yes, often the majority partner is less concerned, but in real estate, it's important because they may not have that immediate liquidity to do it. If we're partners and we're invested in, $10 million worth of buildings, but all of our money is tied up in these buildings, we may not have a check to $3 million to write to our minority partner without refinancing or recapitalizing our property. So in that context, it still could pose a difficulty. And it's even more so for the minority partner, because they may not have the cash flow to buy out the bigger partner. So even if it's majority versus minority, it's something to think about, especially in the real estate context. And one of the ways to deal with that, especially like a death, is in your neck of the woods, and is thinking about, well, it's not property insurance, but life insurance. Can we buy that on a partner or on each other to help defray some of that cost? So we're not going to have to sell one of our properties or liquidate at an inopportune time if something like this were to happen. So it's thinking about all of these events ahead of time and making sure that, hey, if I am the minority partner, do I have the money to buy you out? And if I don't, am I able to structure that over a longer payment period or use something like life insurance to help defer some of that initial down payment to redeem your equity stake in our partnership?
Well, and again, just to, that issue of you love your partner, but not so much the family or, the other parties or whatever. I mean, you've got your own family kind of thing. And it just, from experience, I can tell you, it gets really messy. And if you don't have it sorted out, it can be a messy, expensive, long, protracted disruption to your life. So I would highly encourage you to sort that out up front. I want to ask you, so on these other couple of topics that I'd written down here, lease, purchase, or excuse me, let's look at the purchase agreement in commercial real estate. What to look for in a purchase agreement or commercial real estate transaction? Can you point to some key things that you would encourage the listeners to look for?
Sure. It's with real estate investing, it's hard because you're really focused as the investor, sponsor, developer. You're really focused on getting the deal done, and you may overlook things like the purchase agreement. This is a form document my broker gave to me, or the seller proposed it. What's the big deal? But that's where a lot of issues come up. One of the big issues is a limitation of liability in the commercial context. If sellers often want them, they want to be able to wipe their hands of the property when they're done. They don't want you coming after them, suing them for a substantial portion of the purchase price a year later. And it's a fair concern, but from the buyer standpoint, you also want to make sure you're protected. You may have done a great job doing due diligence, but you weren't able to discover some side lease the seller had, or some environmental concern, and it comes to light later. You want to make sure that you're adequately protected and that you can get justice from the seller and make sure that the value you paid is the value that's fair. So that's one of the areas that's really negotiated is there a fair cap on a seller liability? We see it anywhere from 2 to 5% on multi-million-dollar deals, but it really ranges. And is there a time period when we can make these claims? If I'm selling a property, I eventually want to be able to keep it in the past. I don't want to claim from a buyer to come 3 years in the future. So I'm really going to have my attorney or broker really negotiate this and say, can we cut off any claims after 6 months or 12 months, 18 months? And so I can draw that line in the sand and say, that's my period of exposure. After that, I'm done. And the same thing with the buyer side. Buyer, you got to get in there. You got to do your due diligence, know your property. And if there is a claim, you have to bring it timely. So I think that's one of the big contentious issues that we see with purchase agreements. Another one is dealing with representations and warranties, which I think is really important. In smaller deals, single family properties, you really don't get into them as much, but as you start to grow in commercial, industrial, large multifamily, retail, office, you'll really see representations and warranties from the seller, and to a lesser extent the buyer, that talk about has the seller operated the property in the ordinary course of business? Does he know anything? This is what you're really trying to get at. Is he aware of any environmental concerns with the property? Does he have the right to sell the property? Does he know if any tenant is filed for bankruptcy? And going through certain important questions that, while you may touch on them on your due diligence, this is your opportunity to really ask questions of the seller and to have it in writing where she is standing behind it. So that's probably another area in your purchase agreement that it's really worth taking the time to understand and see what's in there, because This is what protects you post-closing. Sellers made certain representations, and those are the ones that survive the closing for that time period that you're able to make a claim after the fact if need be.
Is there I'm assuming that each case is different, but is there a range of time for these types of matters for the exposure to be still open, as far as if you're the purchaser, if you're the buyer, as far as your window of discovery? Is there a kind of a standard window for some of these things?
It really depends on the owner because, if you're an absentee owner or if you say you have an industrial property and it's leased, you may not really get in there and know your own property. Tenant may not bring certain things to your attention versus if you're buying a duplex in a small real estate investment, you may really get in there. You may have vacant units. You may play around with your sink. You may do a survey and really get in there. So it depends, I think, on the asset class and the involvement of the buyer. But I say you really need a minimum of 6 months to get in there and get familiar with the property post closing. Let it run under your books for a while. So when we negotiate representations and warranties on either side, we try to stay in that short window, 6 months for a seller, and maybe push it out to 18 months for a buyer and negotiate somewhere in between. Because the real key with, I think, real estate and negotiating purchase agreements, leases, even buy sells, is being reasonable and finding that compromise that works for both the buyer and the seller. That's your best deal.
Yeah, I just sitting there thinking of some different transactions that I've been a part of, and I mean the environmental thing you bring up is definitely one that's tends to have kind of a longer, um, seems like a longer due diligence, based on just even the lenders are pretty particular about making certain that they're not going to be lending on a problem and it becomes their problem um, down the road. Um, Curious on the purchase agreement. We're talking essentially about some of these due diligence things. I think so often due diligence uh, is thought of by real estate buyers as more of the physical asset due diligence. The structure, the age and condition of things, that repair items that may need to be taken care of or addressed. Um, is there a like a checklist or some things that you find that are common that buyers don't look for or should look for, or any kind of best practices with respects to more of the contracts um, on a due diligence kind of thing? Like I said, I feel like most often I feel like people frame it in more of a structure, the physical aspect of the transaction, as opposed to the written part of the transaction.
You're absolutely right. A lot of, especially newbies, will look at, did I do my physical inspection? And did I do the financial underwriting? What are my rents? What am I paying? What are my costs? But there's a lot more to underwriting a property, especially from a due diligence standpoint and from a legal standpoint. One of them is, did I look at environmental concerns? You clearly think, if I'm buying a retail property and there's a dry cleaners or a gas station, it comes to mind. But what happens if that gas station is behind your property or across the street? Has there been groundwater migration? Is your next door neighbor a dirty user? Because if it's under your property and your tenants get sick or there's an issue, it can fall on you. So you hear phase one a lot. And what that does is, it's an inspection. It takes time to work into your due diligence, but it's meant to protect you and really understand the environmental aspects of it. Did you really look at the title and survey or have your advisor look at it? I have a client buying a building now, and there's a deed restriction on this industrial building where it's from 1924, and it says you can't serve alcoholic beverages from the premises, and it's actually still valid. So while it didn't immediately affect him, if he wanted to open a tap room or have a tenant there serving alcohol, it's forbidden. And if it's got a pretty severe, you know, violation. If you violate that, there's a reverter, which means the property can technically revert to that owner from 1924 or its heirs. Yeah, that seems pretty wild, but there are cases like that, and we've run across them in different aspects. So if you're not really looking at your title commitment or preliminary report, depending on the state you're in, and not just looking at the exceptions to title that the title company is not going to protect you over, but print those underlying documents and see what they say, because you'll be surprised with some of the restrictions that are in there. And it's something that you would have no idea if you just looked at your physical inspection. You wouldn't get it from an environmental report. So you really got to hit all of these different areas in your due diligence. You do your physical, you do your financial, you do environmental, you do title. Maybe you do a survey, depending on the property type, because you want to make sure there's no encroachments. Your neighbor's not going to make you tear down that expensive shed you just built, or this parking structure because it encroached onto their land. And then, as you said, really understanding any contracts. Are there contracts that I have to assume as the buyer because this is a larger building? What about the leases? Do I understand the leases? And is my tenant, have I gotten an estoppel certificate? What that is it's a certificate that says the tenant is telling you, the buyer, what's in the lease. My lease is in full force and effect. I've paid rent through so-and-so date. I'm not aware of any defaults. And it's an important document to get because we've had situations where the buyer's under the understanding on a multifamily property. With this certain case, there were three tenants, and one of them had a side letter agreement that wasn't part of the lease. The landlord, there was a death, and it was the mother that did it. He wasn't really aware of it, but there was a side letter that granted this tenant the right to lease the property for 5 years at probably 25% of fair market value.
25% of?
25% of fair market value at the time. And it wasn't in the lease. And the seller wasn't even aware of it because it was his mother that was unfortunately deceased. So if he had had an estoppel certificate and the tenant said, I have this, he probably wouldn't have bought the property. And if he'd asked for the estoppel certificate and the tenant hadn't written that down, then the tenant wouldn't be able to say that he had it 3 years. He's bound what's in this document. So from a contracts perspective, really understanding your contracts and some of the legal means that you're really able to use as the buyer or the seller to benefit yourself in that transaction, to make sure you really understand what you're buying to avoid problems that can inherently come down the road.
Let me ask you on the estoppel. Is it an estoppel agreement, or what's the proper word? What is the estoppel?
We typically call them estoppel certificates.
Certificate.
And the name is what it sounds like. It's called estoppel. It's the legal language, but the tenant is stopped from denying what they put in this agreement. So if they write, this is my lease, and they sign off on it, they can't later claim that, oh, that's not true, landlord, buyer, sorry. This other document's my lease. They're stopped from changing what's in here because they're making representations to you as the buyer. And oftentimes on a refinance, they're making those representations to a lender.
Gotcha. And is it ever the case that the seller will do this pre-listing, or is that, I feel like that may give rise to unsettled tenants if you do that? Is it more common when there's a purchase sale agreement between the buyer and the seller that the certificates or the attempt to get the estoppel certificates is handled?
It's usually during escrow for one of the reasons you mentioned. If you don't have an impending sale, you don't necessarily want to alert your tenants, have them concerned that there's a new landlord that may not be as friendly or accommodating as you are. And as the buyer, you also want it to be current. So if the seller got this 6 months ago, that doesn't help me understand, are they current on rent? I want to know if I'm buying a building in August that they've paid through the month of August. So I want that to be probably within 30 days as the buyer. But it's something to be aware of. It takes time. The lease may not require a tenant to give one. Commercial tenants, they may have 10 business days, 20 days to get it back to you. And with large multifamily properties, you just say you're buying a 100-unit apartment building, you just may not physically be able to get them from all the tenants. So it's something to consider when you're even drafting a purchase agreement or an LOI or term sheet. When you're talking about your due diligence time period, am I going to have time for this? Even more so in the current, you know, climate we're in with the COVID-19 pandemic, you may not be able to reach might not be able to reach tenants. Tenants may not um, be as willing to give you documents or exchange things. You may not have access to their units in due diligence. So it's really thinking ahead in terms of timing, and the estoppel certificate is one of the items that does have a lead time to be able to get it back and really read and decipher what's in there.
It's been a little while since I've dealt with one of these, but I'm just trying to remember, is that something that typically the buyer will stipulate in the purchase sale agreement?
Yes, usually we'll negotiate, as part of a negotiation, is the seller going to obtain it from the tenant? If the tenant doesn't give you one, what happens? Do I have the right to terminate the deal? Can the seller give me one and the tenant instead? And if it's a large property, do I have to get one from every tenant, or is there a certain threshold? Can I get one from 80% of the tenants, 90%? So that is something that is negotiated up front in the purchase and sale agreement.
Got it. There's a note here about negotiating a lease on your terms. I'm curious, a lot of times, well, let me ask you, from an investor standpoint, as opposed to the tenant standpoint, what are do you have kind of a frame of reference, for a good guide on how to handle that?
It depends on, the typical lawyer response. It depends. One of it depends. Are we talking about a residential lease or a commercial lease? But I think from an investor standpoint, if you're acquiring a building, it's, your first job is to understand your lease. If it's a residential lease, what constitutes a tenant's default? How long is the lease? What's the term? Look at your financial financial parameters. Then take a look at the legal side. Is there an indemnification provision? What does the tenant have to repair? And really understanding those material facts. And when you're negotiating a new residential lease, is making sure that it protects you as the landlord, but you also want to be, I think kind of the overall theme is be fair to the tenant, but making sure you really understand those default provisions, because from a residential lease, tenants often, they may not have the financial wherewithal of a large corporate tenant, and if something goes wrong, you may just want to be able to get them out of the property. So understanding the default. With a commercial lease, again, investor, you want to understand the deal and what's in the lease, but also look at those bigger points. Does the tenant, are they obligated to give me an estoppel certificate? What costs am I able to pass through to the tenant? Are they paying me a gross sum like a residential lease, a fixed amount, and that's it? Are they paying me a pass through? So understanding the financial parameters, understanding is there an indemnity provision where they're going to protect me if something happens in their building? I'm not liable for that. Is there a limitation of liability? So looking at it not just from a number standpoint, underwriting, but looking at it from what's my exposure? What's my risk exposure? If I've got a big tenant and a pipe breaks and it floods their space, am I liable for that anyway as the landlord and investor? Or if insurance doesn't cover it, do I have exposure? And can the tenant come after me for what's called consequential damages, which is it's the nasty type of damages, because what that means is it's not just pipe breaks, it's a clothing store, I got to replace their clothes. But the consequential damages you want to make sure is waived, because that type of damages, it's the unforeseen damages. The tenant had a shirt in the store, it was worth $50, but it was special. It was going to be worn by a movie star. It was going to get the tenant national exposure. So you cost them $1 million in free advertising. Now they're suing you, landlord, for $1 million. Going through the lease and understanding that. And if you're negotiating a new lease, again, be fair, meet in the middle, but negotiate those points that actually have a financial, business, legal impact to you, and don't always sweat the small stuff. Look at what's actually going to have an impact on your pocketbook or actually expose you to risk.
Let me ask you on the lease. As an insurance broker, we typically receive the lease and have to provide proof of insurance, liability, naming the landlord as an additional insured if it's a commercial lease for the tenant, kind of thing. But I'm kind of curious. There's always a clause in there that seems like it's a catch-all, and if this doesn't remedy it, and if that doesn't remedy it, then we're going to hold you responsible. Am I making something up, or I'm not looking at a lease right now, but it seems like there's always some sort of I can't remember the phraseology, but I can remember years ago having a situation that was not covered by insurance, and it ended up being the tenant's responsibility, damage to a building, kind of thing. It was a weird deal. But I remember the landlord's representative pointing to this section in the lease. Does any of that make any sense to you, what I just said?
It does. And again, another reason to understand the lease, a lot of times you will have the insurance provisions. You'll often have a waiver of subrogation, which means, you know better than I do, but insurance companies are not going to come after you if you're covered. But what happens when there's a gap in insurance or something was unique? You didn't have insurance. A lot of times how the lease is written, beyond, if insurance doesn't cover it, landlord or tenant are ultimately going to be responsible. If the burning bills burns down and there's $1 million in coverage and it costs $1.5 million to rebuild, someone's going to come up with that $500,000. And that's where shifting the risk and exposure comes to play in a lease. Is that the landlord's responsibility or the tenant's? And even then, if it is the tenant's, is it from any action the tenant takes? Or does it have to be some type of standard? Is it because the tenant's that was grossly negligent or willful misconduct? So you're absolutely correct. It's in the lease, and it's another area that's negotiated because it's a shifting of risk. A lot of times with building damage, it is going to fall on the landlord. At least we try to when we represent tenants and vice versa. But if the tenant does something out of the norm and they were negligent, then that whole cost is going to get switched over back to the tenant.
Right. Yeah, I think that's kind of what this situation was. It was a little unique, but no, I think it's the indemnity clause, if I'm remembering right, was kind of the where they kept pointing to was, hey, read this kind of thing, and so that's how that got settled. Jeff, if we could, I'd like to shift gears a little bit here, kind of along the same line of what we've been talking about, risk and that. As we've been talking, by day I'm an insurance broker, and I work with my clients to assess risk and determine what we can do with the risk. And there's a couple of different strategies we consider. The first is we look to see, is there a way to avoid the risk? If that's not possible, we look to see if there's a way to minimize the risk. And when we can't avoid it nor minimize it, we look to transfer the risk. And that's what an insurance policy is. And I like to ask my guests if they can take a look at their situation with their business, their clients, the real estate that they interact in. And if you're able to identify what you consider to be the biggest risk. And just for clarification, I'm not looking for necessarily an insurance related answer, but if you're willing, I'd like to ask you, Jeff Love, what is the biggest risk?
To me, it's the same for me because I'm a real estate investor myself, as well as advising real estate investors. And to me, the biggest risk with real estate is exposing my non-real estate assets to a real estate related risk. And what I mean by that is if I own a 2-unit apartment building and the tenant has a party, someone slips and falls, now I've got a claim against me as the landlord. It may be a really bad fall and someone dies. and they may want to sue me. It's a $5 million claim. Now, I may have insurance, which I hopefully do, get it from someone like yourself, and that gives me protection. But what if that insurance isn't enough? My property insurance, my umbrella, that only gets me to 3 million. How do I protect myself? Because I don't want my bank account, I don't want my car, my kids' college funds, my home. I don't want that exposure for one particular investment. Real estate's just one aspect of my portfolio. I want to try to keep it contained. And one of the ways we do that is through insurance. And that's my first answer. But insurance may not always cover it. There may be an exception. So how do we go one step further? And to our clients, that's part of our corporate practice, our entity structuring, and what those limited liability companies give you are limited liability, whether depending no matter what the form, whether it's a corporation, a limited partnership, an LLC. What that does is say, my exposure is only the company. I can't, unless I do something wrong and it pierces the veil, myself as the owner of that company, you can't come after my personal assets. So I take my 2-unit apartment building, I put it into Jeff's LLC. Now there's that slip and fall. They may make a claim against me. They may get my $3 million insurance coverage, and they may take the property to cover the other $2 million of the claim, but that's all I lose. I don't lose my card, my bank accounts. That's all safe. And to me, that's the biggest risk, is being able to really mitigate the risk from each property and segregate my assets to make sure that if one card falls, all of them don't. And so what we do with clients is help them segregate those risks, maybe even have different properties in different companies. One has specific environmental risk. Maybe one is an apartment building with lots of tenants and lots of Amazon deliveries. We want to keep that separate from my industrial property that's worth a lot more money, or my personal assets. So I think that corporate structuring and understanding what an entity that grants limited liability protection, the benefits that can really give you in mitigating risk and exposure.
No, those are good points. Years ago, I had to testify in a lawsuit. One of my clients was injured. It was an automobile accident, but I remember the party that was at fault, their policy was basically a minimum limit thing, and the company wrote the check and said, good luck. They were out of the claim there, and literally it was after that the judge in the settlement was basically looking at all of the other assets like you're describing, and liquidating, or the at fault party could seek financing or loans against them or whatever, but beyond insurance, you are or can be held responsible, or at least the entity, the responsible party, can be held responsible. So I appreciate you making that point. So, Jeff, where can the listeners go if they would like to learn more or connect with you?
I am on social media. First, check out our website, www.gibbsgiden.com. Feel free to email me anytime, jlove@gibbsgiden. I'm also on LinkedIn. Give me a call. Always happy to answer questions.
All right. Well, Jeff, I can't say thanks enough for taking the time to talk. I've enjoyed it, learned a lot, and I hope we can do it again soon.
Likewise. Thanks so much.
All right. For our listeners, if you like this episode, don't forget to like, share, and subscribe. Remember, the more you know, the more you grow. That's all we've got this week. Until next time, thanks for listening to Commercial Real Estate Pro Network's CREPN Radio.